Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode 35, we're going to talk about Scrivener's errors in estate planning documents. We'll talk about what a Scrivener's error is, then we'll look at how those can be fixed, and we'll touch on a real-life story from a recent Supreme Court opinion from the state of Mississippi in the case of Estate of Blackburn. Now, as always, this presentation is not intended to substitute for legal or tax advice. So what is a Scrivener's error? Well, the smart answer, or the smart aleck answer, is that it's the drafting attorney's worst nightmare. But a better answer that relates to you is that it's a drafting error in an estate planning document, or a drafting mistake, which causes the document not to work the way that was intended by the decedent. Now, the good news is that in most states, a Scrivener's error can be fixed, but there are some barriers to entry. It can be very expensive to do so. And as I mentioned, we'll look at a real-world example of this from a recent Mississippi Supreme Court case opinion, Estate of Blackburn. So under state law in most states, you can fix a Scrivener's error, but there are barriers to entry, as I mentioned. First, you have to present to the court clear and convincing evidence of a mistake. And then sometimes you may have to show an ambiguity in order to bring in outside evidence. Otherwise, the court will look only to the four corners of the document for clear and convincing evidence of the mistake itself. Now, it's important to note that ambiguity, or a showing of ambiguity, isn't necessarily always required, especially under the Uniform Trust Code, but some states still may modify that rule and require a showing of an ambiguity for trusts and or wills. And the end result and remedy, if they do find there's a mistake or even an ambiguity, is that there can be a reformation of the will or trust. That is the name of the remedy. It's reformation. And the court will write in and or delete just enough words to make the document capture the decedent's intent. Now, in contract law, we have a similar remedy. It's typically known as the blue pencil rule that ties into reformation, where the court can change the terms of a document just enough to fix the issue. It's usually an equitable type of remedy. And the same thing holds true here, but with a different procedure and set of law. Now, jumping to our case for today, Estate of Blackburn, this illustrates that attorneys often make the worst clients, just to rag on myself a bit there. Now, the attorney in question was an estate planning attorney, and he was deceased, but he'd had a paralegal in his office prepare his own revocable trust based on his notes and instructions. Now, the attorney had one heir, a son with no living issue, and also some remainder beneficiaries, first his nieces and nephews, and then charities. And the attorney died, and then tragically the son died within a year of the attorney. So the trust had started to be administered but wasn't fully administered, and there was a line in the trust that stated if the son should predecease the grantor prior to complete distribution of trust principal, then the trust would go to the nieces and nephews. Now, you may have picked up on the error there, and you may not have, but we'll look at it in a second. But in the meantime, the son's estate and the nieces and nephews and the remainder interest charities all ended up fighting over this one clause, and it went all the way to the Mississippi Supreme Court. And luckily, the Mississippi Supreme Court approved the trial court's remedy of reforming the trust. Now, first off, when you read those words together, it's kind of a disjunctive. It presents two conditions that can't simultaneously be met. One, did the son predecease the grantor? No. Two, did the son predecease the grantor prior to complete distribution of the trust principal? Well, you can't really read those consistently because no trust principal starts getting distributed until the grantor is deceased anyway. So when it says prior to complete distribution, it implies that the son has to die after distribution starts but prior to distribution being completed, but none of those can actually happen unless the son survives the grantor in this case. So saying the son should predecease grantor completely makes this an impossible condition to carry out. And in the words of the trial court, it was redundant and nonsensical to try to read these together. So the reformation approved by the trial court and by the Supreme Court added two simple words. And it simply said, if the son should predecease the grantor or die prior to the complete distribution of the trust principal, then the trust would go on to the nieces and nephews in this case. So a lot of people had to come in and testify in court and establish what this attorney's actual intent had been and what his pattern of drafting and everything was. And the good news in this case is that there are paralegals and an estate planning attorney who had a history and custom of drafting documents a certain way, which helped. But without that outside evidence, it may have been very difficult to establish that there was an ambiguity here, and what that could have done ultimately is left the nieces and nephews with nothing, and then left the assets to the charities in this case. So while there is a fix, it's not necessarily always a good idea to rely on the fix or to ignore the creation of evidence that could aid in such a fix. So if you're an attorney or a wealth advisor or anybody dealing with estate planning, take very good notes in the client interview process to make sure that the intent is clearly established, just in case the document does not reflect that intent. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you again for joining me for this episode of The 10th of an Hour, and I look forward to seeing you in the next one.